Right, we're good. Okay, so welcome everybody to the Profectus Round Table, the first Teams meeting of its kind, and meeting number 2. Oh, is Katie back in? Yep, Katie's back in.
Sorry.
Lovely. Well, hello, Katie. Welcome back. So
You did predict
you always get one troublemaker in the back of the classroom, don't you?
me.
And I think we've just Helen, I apologise. I think I got that very wrong.
Thank you.
You're
Thanks,
welcome.
Katie, for taking
I
over.
needed to take the heat off of you, Helen. I was dramatic.
This is one of those sisters together things, isn't it? I'm sure. So yes, thank you ever so much for everybody taking part. What I'd like everybody to do to begin with is introduce themselves. I'll start. So I'm Darren Leggett of PLG, and I'll be hosting today's roundtable event. Helen, if I could ask you to take over, please.
My name's Helen Claydon. I'm Chief Legal Officer for Hague Legal Group, which is a group of companies all specialising in the private client and property sector.
Thank you very much, Helen.
I'm Katie Edwards, previously at New Law, but just been acquired by Octopus Legacy and sort of head up their probate, quarter protection and some estate planning work.
Thank you, Katie. Neil.
Hi, Neil Fraser. I'm partner here at Fraser. We're specialist genealogists locating beneficiaries throughout the world.
Thank you, Neil. Martin.
Hi, Darren. Martin Holdsworth. I am the founder and chief exec now of IDR Law. We are a law firm, in fact, the only law firm that deals exclusively with resolving disputes about wills, trust and probate, based in the north, but we do have offices in London as well. We've got 30 lawyers doing this type of work and nothing else.
Thank you, Martin. Sinead.
Hi, I'm Sinead. By the way, I don't have cruel parents who called me Sinead O'Connor because that's normally the first thing I get asked.
I've only just noticed.
I always get asked. Yeah. I'm Legal Services Director at Right Legal Group. We started our business in 2014. We grew it from literally being 4 of us. And we are a niche practice that's dedicated solely to wills, trusts and estates.
Thank you, Sinead. Helen has just arrived. Thank you so much, Helen, for joining us. I know you've had a busy morning, and we're just asking everybody to introduce themselves. So if you would do that, please.
Yes, sorry everybody, I'm late to the party. I was lecturing till past and then sort of had to get rid of everybody off there, so I'm sorry I'm late. But I'm Helen Forster. I have a law firm in Yorkshire, HTF Legal. We specialise in sort of private clients, so trusts, tax, wills, probate, as I affectionately call it, old, mad and dead, to all of us in the room here, but not necessarily to my clients. We work, ironically, hi Martin, with Martin Holdsworth and IDL for our contentious work, so he's helping us out in a variety of cases.
Yeah.
So I also sort of author for Tolley's Encyclopedia for Forms and Precedents. I sit on the Law Society Committee for private clients and do a few other bits and pieces as well, and obviously lecture and train as well. So all things private client, shall we say, but I don't really like the contentious stuff. That's where we sort of throw it to Martin.
Thank you, Helen. I'd tell you what is lovely, because from my perspective, obviously not being legally trained, it's sitting here with a group of people that just the collaboration and the way everybody works and the sector that we're in. Everybody's so lovely. That's the first thing to mention, isn't it? Everybody's smiley and like really lovely people to have in a room. But it's that crossover and that collaboration. I really like that. Anyway, moving on. So it was actually the wonderful Helen Claydon that posed this to me the other week. She said, Darren, what would be a really good subject for the next round table would be the cohabitation consultation. And I'll be honest with you, I'd kind of had an idea of what it was about, and I was aware of it. Of course I was, but I hadn't really dived into it because from a property service provider's perspective, it's something that obviously it's great to be aware of, but I wasn't fully involved in understanding it. So I've done my research. And Helen, if you don't mind, Helen Claydon, I better get used to doing that. Mrs. Claydon, if we could start with you, please. I mean, talk to us about this, because you've done some interviews, haven't you? And you've been asked your opinion on this. Go through, if you don't mind, for the people that are going to be watching this, how the law stands at the moment, what could happen, because it's not decided yet, and what's that going to mean to the professionals in the sector that are dealing with it?
Okay, so I mean that's a huge piece that you've just thrown out right there. But what I was focusing on, and what we're probably focusing on the round table, is the third strand of the consultation, because there's talk about separation of cohabitees and that kind of thing. But the third strand is all about the intestacy rules and what happens when someone dies without a will in place. And as we all know, at the moment, the intestacy provisions do not include cohabitees. They are included under the Inheritance Provisions for Dependents Act as a category that can potentially bring a claim, which I'm sure Martin deals with quite a lot. But as for the actual intestacy provisions, there's no provision for a cohabitee. And there's been talk around this area for such a long time. I think the original consultation led to recommendations in 2011, which were read and promptly shelved. And personally, I think that was a lot to do with the fact that it was such a big piece. It's such a difficult thing to come up with the qualifications for what a cohabiting relationship looks like and how that's actually enforced. So to revisit it now, it was really interesting. And what prompted me to come to you, Darren, and talk about it was that we were approached to do a media day to talk about the provisions. So we actually commissioned our own research, and it wasn't a huge study. We spoke to kind of just over 2,000 people, and the results were quite unexpected, really. What we were expecting is quite a willingness for people to say, yeah, absolutely, the legislation hasn't kept up with current trends. We did a lot of background research into the fact that cohabiting couples has doubled in the last 30 years and all that kind of thing. So what we expected was that the public would be really open to this. And what we actually found is that that wasn't the case. And of the people that we spoke to, the largest group of them, which was nearly a third, it was 30%, said that they didn't believe that cohabiting partners should ever be able to acquire the same rights under intestacy as spouses.
Really?
And so that was quite shocking, really. And again, when one of the questions the Law Commission is asking is, what should the qualification period be? And of the rest of the group that said, actually, yes, they should get something along the lines of spouses, the largest group said it should be more than 5 years, the qualification period. So that just got me thinking. And as part of the media talking about it, we talked a lot about what impact would it have on the contentious side as well. So that's why I'd be really interested to hear Martin's views on that. Would this actually resolve a lot of contentious issues? Because that's what they're looking to actually get on top of by changing the legislation, is to prevent as many claims being brought. But actually, would it create more contentious issues? Because then you'd have people saying that this wasn't correct and actually causing more problem. And actually, when you're looking at, I mean, they talk about in the paper, if you've read it, about what a cohabiting couple is, and they have to be in a romantic relationship. Well, how on earth do you define that? Is someone going to go round and check if they're, sharing a bedroom, or do they hold hands when they walk down the street? Do they have an argument once a month? What is a romantic relationship, and how on earth are we going to define this? And also, when does that cohabiting period begin? Because lots of relationships, you don't suddenly make a decision, right, today we're going to cohabit. you know, they start spending a bit more time at each other's houses? Does it mean that they have to only have one property, or can they cohabit and still have their own houses? It's hugely complicated. There's a massive discussion to be had around it. So really, this was about prompting some of those discussions and getting some other people's opinions on it.
Thank you, Helen. I mean, to be honest with you, I think you've summed it up really, really well, and you've posed a question to Martin. So if it's okay with everybody, I'm going to pass over to Martin to answer some of those questions.
I don't mind at all. I was smiling at your how do you check if somebody's in a romantic relationship? I think the problems apply equally to cohabitees, but also to marriages as well. Quite frankly, I think it was Nuremberg. I think his famous quote was, "The multifarious nature of marriage is not for us to decide what's right or wrong within a particular marriage," and I'm sure that will roll over into cohabitees as well. I mean, what I really want to start with for me is just to make the point, the really important point, and I'm sure I won't get any disagreement here on this, is that these are proposals that affect intestacy only. So a valid will override everything. So everything we say and everything we do here is important, because 2/3 of people still not having a will. But the reality is, like most things in our sector, is if you get some proper advice at the right time and create a will, you can rule out virtually all of these problems in the vast majority of cases. So I just wanted to make that point up front and out there while we now delve into intestacy. I mean, as things stand at the moment, and I suppose that's the way to start, is in the same way as you've said, Helen, what the proposals are. Well, what happens now? And Neil, you've helpfully thrown some stats into the text about 12.8 million people being married and 3.5 million cohabiting. This is not a small problem. You know, the reality is that there are more and more cohabitees that exist, I suspect, now. Certainly, this all started early 70s, didn't it, really, with the Matrimonial Accords Act coming in and allowing people to get divorced, and families have changed as a result. For me, the start point is, as things stand now, it's clearly wrong that intestacy ignores some really important, dependent, needy people, which is certainly the cohabitees. There's some very long-term ones. The obvious examples are, sort of, I've had plenty of them in my time of doing contentious work, 20, 30-year cohabitation periods where there's no provision made in a will at all. And as a result, that person gets nothing, and the starting position is you get nothing. We can and always do rectify that using the 1975 Act that you referred to. So it's not that it doesn't have a solution, but it seems to me that is predictable in terms of what's going to happen. And the price that's paid at a time during delay and grief and everything else is in money, and it comes out of the estate. The lawyers get busy, and we do get to the right position at the end, but it's time and it's money. So any exploration into reducing that, I think, is a good thing, and it's a great debate to have. Worth remembering that under the current rules from the 1975 Act is to argue that you've got a cohabitation that brings you into one of the qualifying categories of claimant. You need to establish that there's been a 2-year continuous period of cohabitation, and that actually leans into a lot of the things that Helen's highlighted already. We already argue about what is cohabitation. You know, what is a break in that cohabitation? Is if someone goes into hospital for the last 2 months before they die, and therefore it's now less than 2 years that they've been together, physically together, romantically together, shared finances, whatever it is that you advance as an argument to prove cohabitation. There are already lines at which lawyers fight over and families fight over. So a lot of what I'm seeing is it will just shift the dispute to different areas. And I think one of the big things will be this, what you've highlighted, the threshold question, is that if we're moving from 2 years to 5 years, and if it's 5 years on intestacy, which is certainly the indication I've seen from the papers, is you live together for 5 years, you'll automatically get on intestacy. Well, you can imagine that the dispute lines are going to be drawn on, well, is it 5 years? Was it 5 years? So that all these things will just move around and the fight will still be there. My view is that let's start from a consideration of what is the start point that is least attritional on the family, and debate that, and debate what would be an easier place to start from, And is that better than what we've got now? And if it's not, then are we not better spending our time and our money educating rather than trying to legislate a set of rules that people will not understand? I mean, one stat that I wrote down before today was 46% believe that common law marriage exists. You know, that's despite everybody on this call shouting and screaming and saying it as many times as we can, that is not true, and yet it still exists. So that's, for me, is a fundamental point. Is, do we, when we get to the end of it, do we feel like we've improved anything? And if we haven't, are we better focusing on education rather than on sort of putting a new statute on the books?
That's a really good point. And actually, we, as part of our research, we did the usual questions about, do you actually know what happens to cohabiting couples on intestacy? And 28% got it completely wrong and said they had an absolute right to inherit. And another 27% admitted that they had no idea at all. So that matches the statistics that you're saying, that half of people either don't know or completely get it wrong. And of the other 50%, some of them kind of guessed correctly and some of them got it a bit wrong. But it's a huge amount that don't understand the current legislation anyway. Yeah.
So the point is, whatever we do here, whatever comes out of it, we need to make sure that they do understand it and do understand what that means. Particularly when now we've got lots of blended families. So you can have situations where you live together for 5 years or more. Does that mean that there's an automatic right? There's no, well, yes, it does. And it means that's going to come at the expense of the children from the first marriage who would receive currently. So, you know, I'm not sitting here scaremongering, because the reality is that contentious wills and probate will pop up whatever happens here, because it's a human nature. And if 1 in 3 are relying on an inheritance and they don't get it, whatever the rules are, they're going to have a go at trying to change that result. But I do think it's, I keep going back to, but I do think it's a fundamental point for me, is work out, can we move it to a better starting position? And if we can, what do we need to do to make sure that people are aware of that and therefore plan accordingly?
I think that's all very much food for thought. Before I sort of raise any other questions, Helen Forster's got her hand up and calmly waiting. So please, Helen.
Now, I just wanted to echo sort of what Martin and Helen are saying about this. The common law spouse is what a lot of people seem to think exists. And it's not just the individuals. So I think the education has to line a twofold. It's institutions as well. I was just doing something very simple. I was just renewing my car insurance, and it goes to, do you want to add somebody? And then it says what relationship they are. And genuinely, it said spouse, cohabitee, common law spouse. So we've got a massive problem. I went mental at Helen. I absolutely went mental. I felt like writing to compare the meerkat. But the point that I'm really getting at is, I think we've got an institutionalized problem as well as getting it out to individuals and the greater public. We've got to figure out a way to educate the institutions, because a lot of people are going to see that and make an assumption that you can have a common law spouse. You would, wouldn't you? And I think that's a really scary problem. So it's sort of just echoing what Martin's saying, of getting out to the public, but also we've got to figure out a way to educate these sort of, if we call it the sort of mass institutions that are going out to these people. And how we do that is going to be, again, just a sort of a mammoth problem. I think it's a twofold issue. So that was all I just wanted to sort of kick in, is I literally did that 2 weeks ago and could not believe what I was seeing. But we are where we are with this is people's misunderstanding of the current rules. So I sort of agree with Martin. I think you try and change the legislation, and I think you're opening up a can of worms at the moment of how you would do that and what the limits would be. Am I cohabiting? Because as Helen rightly said, my partner's in a different house, but we go places together. We've just been away together. Does that mean we're cohabiting? It's that horrible sort of thing. And if you're going to start drilling into that, actually the easier option might be the educational bit. But how on earth we're going to then look at that is obviously what we're here today to sort of hammer out, I think.
I think that's again, I mean, one of the things I'm loving about this already is the fact that we're looking at this from a professional perspective, as well as a personal perspective. And when you look at the word relationship, that really is so personal to the people and the individuals that are in a relationship. Katie, what are your thoughts? What are your takes on this? Do you think, because I understand that this really started being raised in June, do you think between June and August, is that enough time for a decision to be made of this magnitude, or kind of what are your views on things here?
No, I mean, this is a huge area of complexity, and if you're talking about areas of grey, this is it. Relationships are difficult. Everybody has different views on how they approach relationships, and to be able to have legislation to cut through those areas of grey, that's difficult, but to give it a short timescale is even harder. I think the short timescale is probably in recognition that everybody wants reform, but it's what does that reform look like, and how far does it go? And for me, when I was sort of reading through the different strands that they're trying to approach, the intestacy position is just so much more different to all other aspects of the legislation that they're trying to get through. So you've got all of the echoes of protecting vulnerable people, primarily protecting the children in these relationships, but actually the intestacy position operates against the children. So you've got quite a juxtaposition on how that legislation is kind of coming through. I appreciate it will protect the children in some instances, but not all. So those are quite sticky things to sort out. And just personally, I cohabited with my husband for 7 years before we got married. I'd have been horrified if he'd got anything from my estate. Prior to that sort of formalization of a relationship, and this is where I think Helen's coming from with what the people actually think when you talk to them. A lot of people are cohabiting, but they would not want their money to go to their other half, and that's a big sort of challenge that we've got to get through.
So, and I'm going to ask you to stay on talking if you don't mind, Katie.
It's fine.
Let's look at the second family thing, because if you're a chap and you've had one family and maybe the children have got a little bit older, and you go into a new home and maybe those children aren't your own, but you're paying a contribution to the running of the household, you're helping the children with food and all the things that one might regard as cohabitating in a generalized term. What is our understanding on how the cohabitation law would work, or the change in the cohabitation based on that? So I've made no will, let's say for argument's sake, is the family that I'm cohabitating with entitled to more of my estate because I'm there, or my biological children, are they entitled to more because they're my biological children?
Under the existing law, obviously the children would be stepping in as the primary people that would be inheriting, but under the reforms, it's the children are still a priority when it comes to the class of children, but what you're putting ahead of them is that cohabiting partner. So where you're kind of seeing the real impact is in those low value estates where that you're not going to get above that statutory legacy, and everything is going to go to the partner, and the partner then has free reign or under intestacy is going to end up leaving that to their children or under their will. So that's kind of how it's operating against the children of the first relationship. If you had children of both relationships, obviously when it comes to the children category, I think they're all going to inherit on equal measure, but it's that weighting towards the partner which is going to then effectively pass that down to the children of either the joint relationship or to their children if they haven't had children together. And that's where you see that kind of what could be perceived as unfairness creeping in against those children of first relationships. And that is a huge area of contention. And this is where I think Martin's saying is you're just going to get shifting lines of where the contention arises, because you're going to get more contention coming from children from first relationships, and a number of them will be over 18. So that litigation is not going to be easy, expensive, and not sort of clear cut. It's all going to be flowing because they're being disinherited all of a sudden.
I think to put that into context, Darren, just using that example that you gave to Katie, and Katie's set out quite rightly there, is as it stands now, with the individual that's joined the second blended family, if they've been cohabiting for 2 years or more, and there's a financial dependency as well potentially, but at least 2 years of cohabitation immediately before death, then that individual, that chap in your example, could bring a claim against the estate to provide for them, because under the current rules, that person would get nothing, and his cohabitee's children would pick up the loss as it stands. What would change with what I've seen here as the proposals, the key proposals, is that instead of it being the cohabitee bringing the claim, it will be a situation where if the cohabitee has lived there for 5 years, so it's 2.5 times longer, then they will then inherit some form of statutory legacy similar to what a widow would have received at that point. So it's a big lump sum, and as Katie says, most estates fall below that lump sum figure. So it means that the cohabitee would pick up the lot, leaving the children with nothing at all. So what happens, instead of the adult coming to see me saying I've been a cohabitee for 5 years, I've got the children coming to see me saying, we've lost everything. There's no way mum would have understood. This is the knowledge bit. She would never have allowed this to happen if she'd have realised that living for 5 years would have done this and disinherited it. Now, of course, the answer as always is, well, make a will. But again, 2/3 of people make no will, and we're talking about people who aren't doing that. So that's the shift. And the problem with that is, of course, if the children are under 18, no cohabitees under 18. But if the children are under 18 and there's multiple ones, then what you find is it's not just one lawyer usually representing them, it's that they each individually have to be separately represented, and represented by a litigation friend who's old enough to bring and represent their position in court. So you can suddenly go from it being one to suddenly you've got 1, 2, 3, 4 claimants coming back arguing. And again, they're more likely to be brought those cases against estates that are slightly lower, because it's all got, so you're going to end up disappearing. And the net result of all of that will be that there will be less in the pot to divide following a death of somebody important. And that's for me why we need to be careful about, let's see how this plays out in theory before we start enacting it, and then compare the two and see which is the least. They're going to be attritional whichever way we go. So let's pick the one that's least.
Can I bring another spanner into these works? Because I've read through the documents, and at the moment there's no grounds for removing a pre-existing wife or husband. So if you are married and separated, and then you form into a cohabiting relationship, we now have 2 people of the first degree entitled to that estate. Is it possible then to throw another spanner further up the line and say, could you be cohabiting with more than one person at a time? That if you had a family in the north and a family in the south, similar to number 10, then yeah, could you suddenly have 2 cohabitees after the estate as well? Late in life relationships which suddenly remove children from it. Was it a romantic relationship, or was it a convenience relationship for the last 5 years of their life? Did they lost mental capacity? Were they still in a romantic relationship if they didn't have the mental capacity to know where or what they were doing? Does the relationship suddenly end if they move into a care home? There are so many questions which can be brought up because of trying to rule out the fear of common law, that in fact we are more likely to have contentious matters than we are under the existing arrangements.
I don't think you've thrown a spanner in the works there, Neil. I think you've chucked in a whole toolbox. I mean, something that you've just said there really got my ears pricked up. For no dodgy reason whatsoever, I assure everybody in the room. But the dual or multiple cohabitations, like if you've got a family in one part, and we've all seen the ITV and BBC document crime serial dramas about people that have got that, and there's one family over there and there's another family over there that neither of them knew about. I mean, it's going to come up in a death anyway, isn't it? But again, if you're equal cohabitation, I mean, Sinead, have you ever had anything like that pop up? Has there been anything that you kind of sat and thought, oh my goodness, here we go, get ready for the roller coaster ride that's going to be this administration? And if so, how can you compare that to this? I'm sorry, I know that's a really open question.
To answer your question in short, yes, absolutely. I think we've probably all had those EastEnder moments, haven't we, where you find out that the cousin's the brother or whatever it is. But yes, it comes out all the time. The thing that the key thing that I agree with that has been said quite a lot here is it a question better actually of plugging the investment into the education? And that would be the answer for me. I think no matter what they do, no matter what thresholds they set, all we will do is move the argument somewhere else. You think you said that earlier on, Martin. I think one way or another, you will find a way to argue if it's in 5 years, 2 years. It could be that a cohabitation means that you have to have actually bought a property together. I'm definitely more in favour of ruling out the grey areas and creating more black and white if you possibly can. But every strand of thought that I go down, I end up landing on, I just wish people were better educated and we didn't create the grey areas, and we made it that people knew that it was their responsibility to go and put a will in place, make sure you've protected who you want to protect at the end of the day. And if you don't, and it does end up in Martin's team's hands and people are fighting over it, sound probably a little bit harsh, but more for you if you've been educated well and you've been warned. And when the conveyancers are dealing with the property sales, if they're properly educating the clients on what is the difference between joint tenants and tenants in common, and rather than it being a tick box that people just naturally go, well, yeah, well, joint tenants it. I don't think people fully understand what it is that they're being asked in these situations. So I'm all for the education.
In the cohabitation sort of what the reforms are suggesting, somebody could have made a will 25 years before cohabiting, and you're going to have that then of those, that will take effect, that cohabitation will in theory be ignored, because that, so it's not just, it's that education to make a will, but also then to keep everything up to date. I've seen so many times old documents and policies or wills which are just leaving things elsewhere.
I think the biggest problem that's really becoming apparent is that when you get married or when you terminate a marriage, it's a conscious decision to do that. Whereas these provisions, even with qualifying periods, you can almost accidentally fall into a legal relationship. And I think that's the biggest problem.
I agree entirely, Helen. I mean, you've probably all heard the story that Daphne Frank on predatory marriage. I think most of us have probably heard her speak over the years. Now, I acted for Daphne very early on in this, and her mother, Joan Blass, was the victim of a predatory marriage by the chap concerned. And it leans into one of your points, Neil, about capacity. We talk about the capacity to get married, and the bar for that is pretty low in terms of how it's managed. Is that you turn up at a registry office and, do you want to get married? Do you want to take this person? Yes, please. And unless you're actually demonstrating visibly some kind of capacity issue, you'll get married at that point, and the marriage evokes will.
We do have 28 days notice. Yeah.
So you get that kind of point where a secret predatory marriage will have the impact. My worry here is that unless we, and this again is the bits around the edges, isn't it? But I could see predatory cohabs coming in. Is that somebody moves in 5 years later? No. We went on holiday together. I did the shopping. It doesn't matter about contribution, because some marriages are unequal contributions, some cohabited. The fact is we've been together and we did everything together for 5 years. So therefore, I'm now a qualifying class. Yes, I may have started as a carer, but I'm now a partner. I'm now a cohabitee. Very difficult, evidentially, because your best witness is always going to be dead. So you're completely reliant on those around, and those around invariably will have some interest in the result. So their evidence is a little bit questionable as a result. So it's, again, it falls back to, and I think you're absolutely right, Helen, is that one, to me, is an absolute choice that you have to engage in. The other one is it will be imposed upon you, whether you want it or not. You may have chosen not to get married, but we're going to impose the similar obligations on death as we do as if you had got married. So it's that's that balance again, isn't it?
That was the biggest point I made in my notes here. The difference between choice and consent. When it is how it's proposed in the consultation is a automated opt-in as opposed to any other way around it. We have provision at the moment through marriage, through civil partnership to draw that line. The problem when we're trying to fit life into a set of circumstances and tick boxes to decide who is and who isn't cohabiting, and whether you can be cohabiting even if you're living in different properties, is incredibly hard. The civil partnership provision at the moment is massively underutilized. There's less than 10,000 civil partnerships in the UK every year, compared to just under 250,000 marriages, and 85% of marriages are civil marriages, so not religious marriages. The civil partnership function, which was set up for same spouse to give them the right before the marriage came in, is massively underutilized. And we could actually use a civil partnership avenue to register that you are cohabiting and you don't actually want to go through a marriage ceremony for some reason. And it is the problem with not being able to have that finite point, that line when you say, I am not married, I am married, I'm not cohabiting, I am cohabiting, is it's just opening up more contentious matters than the existing situation.
Yeah, absolutely. I mean, it's interesting. We talk about who's where. I mean, you've got census, council tax. The people know where we are. I mean, we talk about Big Brother, and we were having that conversation in jest before we had this meeting, or started this meeting. Helen, Forster, sorry, you've got your hand up again, waiting ever so patiently.
Yeah, no, I just wanted to, I'm going to play a bit of devil's advocate here, because I'm going to put my committee hat on for a second and say, look, we've got the will reforms that, of course, we know didn't get royal sort of mention this year, but the whole sort of section to do with protecting people and perhaps more vulnerable was indeed where Martin sort of tacked on with the predatory marriages. And of course, the proposal being marriage is no longer going to revoke a will. That's the proposal. And of course, the whole point of that is then you have made a will specifically for those beneficiaries. And therefore, even though you're married, the anticipation is you would make a will to maybe divvy it up and sort it out. But it reverses who has that automatic claim. And so if we're sort of looking at this, saying, well, from a cohabitation perspective, have they already got protections? They do, don't they? Because you could indeed, if I was, and I've successfully managed to sort this out for somebody who was cohabiting for 20 odd years, and they found their partner dead on the kitchen floor, sadly, when they come back from work, they'd had like an aneurysm. They weren't indeed on the policy for a pension. I think it was nominated to nephews. But we successfully sort of submitted the details to the pension trustees, evidenced the situation, and they said, yes, we'll actually pay out because the circumstances have changed. So I think there's protections there already. They can make indeed an Inheritance Act claim, and I'm sure Martin will sort of go into the detail. But as I understand it, if you've been cohabiting for 2 years prior to death, you've got a sort of protection there. So are we, by suggesting some significant reforms to say they've automatically got rights, are we sort of going almost against the legislation that we're proposing to try and protect people for the fact that they've got these children from other relationships and they're the key people we want to benefit, by potentially bringing in cohab reform to protect cohabitees when they've already got this ability? So it's just playing a bit of devil's advocate here to sort of the room in general on this, because they do actually have that ability. Whether or not it's enough is, of course, another question altogether.
Sinead?
I do agree. I think that they've got a route to go down, haven't they? So, you know, if they choose to not make a will and to put themselves in that situation, then I'm all for, you know, really protecting the people that that need it and deserve it, and where there is a legitimate claim. I think you said earlier on, Martin, the 20-odd year cohabitee situation, it was probably nailed on from early stages that, you know, this person's going to be successful. So they have got an avenue to go down to make sure that the right people do end up ultimately inheriting. I think the other thing, just as everyone's saying spanners, I'm trying to think of something else I can throw in there, but it would be interesting, I think, to understand from the government perspective, if they do go down this route of, well, let's try and widen the scope then, and let's bring people in so that we can recognise that people might not want to get married nowadays, but we'll treat them as though they are. Will they treat them as though they are from an inheritance tax perspective and extend the spousal exemption to them? Probably not.
No, you're right, Sinead. At the moment, as it's seen, I mean, I just wrote the phrase down, you inherit as a spouse, but you're taxed as a stranger.
Yeah.
Is that you inherit the big lump, particularly if you're looking at pensions dropping in next year as well. You know, you're talking about a sizable amount of money. So you inherit as a spouse, taxed as a stranger. You know, and you know, cynic in me sort of looks at that and goes, you know, if people don't understand, I'll still think that common law marriage exists. Try educating them on what will then happen on the tax following that. That's for me. I think you're absolutely right. I think you've known
the government need to be careful though, because if they're pushing the narrative of, you know, we should treat cohabiting couples as though they're spouses, then if I was a cohabitee, that is what I would then go for next. Well, let me get the tax benefits as though I'm a spouse as well.
And that brings also into, you know, transferable allowances and resident nil rate band qualification. It's a huge piece, but you're right, there's no mention of that at all.
There's nothing on tax at the moment sort of being suggested, and they're probably bringing a cohabitation nil rate band or something like that, you know what they're like.
And also maintenance at the end of a cohabiting relationship. So you've lived in a cohabiting relationship and it's got 10 years. You've now split and separated. Are you therefore entitled to maintenance as well?
Well, that's the interesting thing, you know, is because as it stands at the moment, there is this kind of sort of split paradox between two people living together as cohabitees, splitting in life. And very, very little you can claim for as a result of that, unless you've contributed or you've got a deed of trust in place, or you can demonstrate some kind of equitable trust, is you get to keep what you put in, basically. So it's still in your name. Compare that and contrast that with death. You survived for 2 years prior to death on a cohabitation, exactly the same facts, but it's a death rather than a divorce. And the current legislation, the 75 Act, allows you to then bring a claim for reasonable financial provision that's maintenance. You know, so there is this kind of paradox that exists already, and what's being proposed would kind of even that out. But I don't think it works. I genuinely don't think it works. I think that, again, there are positive things you can put in place when you start to live with somebody. Your example earlier, Katie, if you move in with your husband first and you're cohabiting, you'll sit down and work out education about, okay, deed of trust, how do we make sure that this is fair if we don't stay together, you know, and that's the conversation to be had, isn't it? But I do think the
cohabitation agreement, isn't it, Martin? It's your cohabitants.
Exactly.
The other thing that has been suggested as a proposed reform is that you're able to opt out of this. So what does that look like? Because you've got to be aware of it to opt out of it, which kind of comes right back to what everybody in this forum has been talking about. How do you educate people that this exists in the first place? Katie, what's your thoughts on that?
Yeah, I mean, an opt-out, you could look at opt-outs and opt-ins as these proposals. You have got exactly the same problems. You can currently opt out of the intestacy rules by making a will, yet people still aren't doing it. And so it's the exact same position as we've already got, but with even less knowledge. At least people who've experienced wills do understand this. So they might, what we find is you get a lot of education coming through experiencing it with a parent. So they've experienced an issue with a parent, they've then learned sort of their lesson a little bit, they've got their wills sorted for the next generation, but you won't even have that educational piece coming through from that historical way of dealing things. So we're just starting again with an educational piece. So I think if it was me in a cohabiting relationship, I'd rather opt in than opt out. But I think you've got to balance that with the vulnerable people as well. So I get it. It's a very difficult area, but this is a hugely difficult area, which brings you back to that short consultation period being, how is that long enough to really debate all of these points and things. And the one thing that I think is interesting, as say, for example, this does get traction and does go through, what I was quite interested in is that it is being given as kind of the equal amount to a spouse. So if you had an Inheritance Act claim, for example, at the moment with a cohabitee, I don't think that Martin will tell us in a far better way, but in those instances, everybody's looking at the assets in consideration and getting a fair result. So you might find life interests, you might find different ways of providing for a cohabiting partner that is not giving them a chunk of cash. And we're losing all of that by giving them an amount which is equal to what a spouse would receive, which I was quite surprised by to a certain extent, because that's not measured at all, and it's a much lower bar to cohabit than it is to get married.
I agree, and just following on your point, under the 1975 Act, you can make an application as a spouse, surviving spouse, or a surviving cohabitee. The surviving spouse, both are reasonable financial provision awards if you're successful, but the way in which they're calculated are materially different. Is that the spouse, surviving spouses, it's about what's fair and reasonable, not just about what you've got and what you need. It's about what's fair for you to receive out of it. And that, in fact, there's some kind of notional divorce cross-check. So that's how close it is to the idea of divorce. You sort of ask yourself, well, if this person had been divorced rather than died, what would they have got? And we'll look at that as a figure to start from. So that's for spouses. But when you've got cohabitees, it really comes down to what have you got, what do you need? It's about financial maintenance. Is that, what do we need to provide for you? Do you need a roof over your head? Do you have an income shortfall? It's all about the numbers. And those awards are far lower usually than they are for surviving spouses. So if we are going to equalise this on intestacy, should we therefore then be equalising it on the 75 Act as well? Particularly because to engage the 75 Act is 2 years, not 5. How does that make sense? Is that we need to make sure that these things are aligned, so that what we're presenting, again, we all keep talking about education, but is how many times do we have conversations about it's 6 months from the date of the grant of probate to bring a 1975 Act claim? And yet I train lawyers and teams who, half of them still don't know when does that 6 months start from. So actually educating the public on this is unless we're absolutely clear and solid, I don't know how that gets done.
It's a hugely different estate planning question as well, because our conversation yesterday, Martin, was around the will writer having an obligation to notify of potential claims when you're making a will. What is that? Is that claim suddenly greater, more valuable?
Huge.
Are you having to give them more under the terms of the will to try and balance that out? So I think it has a lot of far-reaching effects, which perhaps haven't been envisaged when initially looking at this.
It does. And the opt-in, opt-out, Darren, is I don't mind that if the safeguards are in place. So disclosure, independent advice. I think it's the way to look at that is in the same way as a prenup. Is that prenup will stand if full disclosure, independent advice, everybody entered it equally, equality of bargaining positions. But what you do get, think about the big case that was heard was Radmacher, wasn't it, on in relation to prenups, and that just ran and ran and ran because of this fight saying, well, prenups, can they be enforced? Well, opt-out agreements are exactly the same. And coming back to Neil's point, is that you will find satellite litigation will kick off on, well, they opted in or out because they were unduly influenced, or there was a non-disclosure, or there was a stale agreement because things changed and moved on, or you can see how these things are all going to play out. Again, I don't think there's an easy solution. I really don't. I know I keep coming back to it, but it's how bad is it now compared to how much better we can make it? And if the answer is we can't make it better, education. I keep repeating myself, but I'm just so sure that that's the right way to do it. But
Helen
And I would
Claydon.
argue we probably do have the ability and documentation and things that can work for it now. We have the cohabitation agreement, which we could make, like you say, it's not legally binding in some cases, I know, but if you make it more robust, if we drill down on those, and educate on these sorts of things, rather than the minefield of trying to change legislation to effectively bring in, I think we're basically saying we're bringing in that common law spouse. That's the potential, isn't it, for want of a better description here. And trying to navigate that minefield versus actually firming up on the things that we've got that can work if we do them right. I think there's maybe an avenue to do that in probably a much better way. It's how then we get that out to the masses. I mean, I used to argue that the key place for marriage, when people said, oh, we didn't know our wills were revoked because we got married, the registrar was the obvious place to have that information, isn't it? Oh, you're getting married, you have that interview, don't you, where you're supposed to know your partner. They could easily provide that information there. Where we would do that for cohabitees, I don't know, but there is sort of this ability. There are places where we can get this information out, and it's just a question of maybe utilising what we've got first before we go down this mass route. But as you say, we've got a very short period of time.
Yeah, a really good point. Just thinking about, just following your thought, that if we have to educate, it seems to me that it's almost a domino effect to this. We're going to have to sort of revisit so many bits of statute and legislation to make it right, even before we get to the tax ones. Is if you've got to go to, you can go and find, you can get a marriage certificate. So you've got a document that's stamped, absolutely they're married, we know we're okay, we can treat them in this way. What happens when you've got, when somebody dies, just the practical reality of it says about equal non-contentious probate rules priority being applied to these qualifying cohabitees. Can you imagine the conversation at the probate registry about, actually, I can now apply for a grant? Well, why? Well, I've ticked the box that says I've been cohabiting for 5 years.
That relies on them having a conversation at probate registry. That's a whole different discussion, isn't it?
First mistake. Yeah, you're quite right. Is that how do you, date of marriage, copy of certificate, done. How do you do it on a cohabitee? What you're going to find, therefore, is that on every intestate situation, you're going to get caveats logic, standing disputes, pre-grant litigation. You're opening up at the front, because at the front, if you don't object to them taking control, then are you seen as consenting and allowing them to proceed on a basis you don't agree with? It's only 4 years, or it wasn't a relationship, or I haven't thought about that before, Ellen. Actually, just following over your point, is that just the practicalities of dealing with the executive and the courts is my goodness me. Yeah.
And they're the ones that are going to receive the multiple applications from the different cohabitees.
They'll get loads. Yeah, exactly right. They'll get 5,
and they'll be like, oh, and it will just.
You could bring something in to say, well, you've got to agree you're cohabiting, so some sort of signed document. But then you're always going to have this situation of, well, you can't force people into doing these sorts of things, can you? So how do you do it? And it's just, I can just see these sorts of issues just spiraling, and we just like you say, we just haven't had enough time as yet to drill down on it, rather than just going, yeah, that sounds like a great idea. I think there's just far too much at the moment, which does worry me greatly. And I think you've hit the nail on the head there, Martin, of just, you can just see this suddenly going, hang on a minute, what's going to go from here?
I think that's exactly what happened when they issued it originally in 2011, that a lot of the responses that they got and the conversations that were then started, they just realized that it was just a huge piece with all these definitions and qualifications, and that they couldn't legislate for. It was just too big, not to mention all the additional things that would then be impacted by that, and the additional legislation that would then have to recognise this as a legal relationship. It just opens a huge can of worms, doesn't it? But it's interesting that they were asking, they kind of separated it out, didn't they, about the intestacy provisions, and then had a separate question about should a qualifying cohabiting partner also then be able to apply for the grant. And I think that one's probably a little bit more clear cut, in the sense that it's not clear cut at all. It just creates huge issues. What they also asked about, which I'd really like to hear Martin's opinion on, if I can, Darren, sorry, was if a couple have been cohabiting at the date of death and have children together, they're proposing removing the 2-year qualification period. I don't do enough contentious work to know, is that a good idea, or does that create more problems?
Well, I think the logic is sound in the sense that there is whatever the relationship type, they're leaving behind somebody in need, somebody that can't be ignored, and somebody should be around. What this seems to do is extend that obligation back up to the parent who's been cohabiting to allow them to receive funds, etc. So I think the logic is sound. My worry is okay, if this is a short relationship producing a child, that particularly with blended families as we've now got very often, if we're thinking about death, thank goodness we don't die usually until we're fairly aged, usually. So invariably, if you've got children around and it's a short second marriage, it's not 5 or cohabitation of less than 5 years, invariably they're going to be the older group. So they're going to be probably more likely than not second marriages or second cohabitations, relationships. And that's going to displace grown-up and existing children from first. And it comes down to planning and warning. If I could describe a dynamic that is more prevalent than any other in litigation following death, it would be the blended family situation for fairly obvious reasons. And it's even more likely to happen where there is a significant difference in age between first set of children and second set of children, because there's no relationship between them. They never lived together. They never shared a space. There's no kind of emotional ties there. So, and they're less inclined to do what may be considered to be the right thing. So for me, if that's the area that's already being bitterly fought over, which it is how does this change that, other than to move the starting position to the second partner, even though it's not 5 years, has a child, therefore they should be treated on intestacy as if they were a spouse. All that will happen is their starting position will improve in the sense that they'll start with a bigger tranche of money, but the fight will then start anyway, and then everybody will then argue about it, and all the same issues will crop up. The difference being is the starting position's changed. And I think that's the thing I keep coming back to when I sort of run through examples in my head, is that you're going to end up in the same litigation whatever they do. What's changed is the starting position. And is that starting position better and therefore promoting less disputes than what the position is now? And I think that's, again, forgive me for repeating, that fundamentally is where I think the assessment should be made and looked at. Because if this is all about certainty, protecting and looking after our families as it should be, then it should do that. It shouldn't just create more litigation, create more uncertainty, drive people away from going to get legal advice because it's even more complicated and more expensive as a result. We need to be focused on what we're trying to do here. And if it doesn't do it, don't do it, will be my view. The protections are in place, as we've all seen, voluntary, and also the statute is there. 75 Act is brilliant, in my view. It works really, really well. The way it's been abused is adults, independent children claims. Let's spend some time getting rid of those rather than the cohabitee ones. It's very rare that I get a cohabitee claim. We triage our claims coming in using AI and humans and all the rest of it. I can tell you now, on the scorecarding, if you're a cohabitee of more than 2 years, you go straight into category A. We know we will get a recovery for you. And that's without a will. With a will, you're going to be in a better position. Now, adult children are way down the bottom, but the reason why they seem to get home so often is because the costs, consequences, and the no fees and all of that driving it. So
and this will drive litigation up from adults.
Yeah, exactly. Let's focus on that. Let's start making some hard and fast rules there, not on the cohabitees.
Is it worthwhile just pointing out as well that even if you are named in the will with a very small sum, so say I made a will for my partner and I gave him £5,000, it's not an either or because I've made a will, that's it. He can still make an Inheritance Act claim. He can still come to Martin and go, I should be more provided for because actually she made that back when we'd been together 2 years, not when we've been together 20. So it's not an either or. You can still utilise these, even if there is a will.
Yeah. Great.
I'd like to ask Neil, because I'm going to look at this in a slightly different way. Neil, looking at it from a beneficiary, a non-known beneficiary, what are we thinking with this? Because if I cohabited with somebody and they're the last person I've had interaction with, they're the last person that might now have a claim against my estate, and I've died, how does that affect air hunting? How does that affect what you guys do at Fraser and Fraser? Is there going to be any changes? Is there going to be any difference? And how would you go about that without giving away any trade secrets, obviously? What kind of impact would that have in your sector?
So there's two areas I think I'd look at. The first is we'd have to be more aware when we started a matter, and there are cases which we research today, knowing that we are only finding a beneficiary in order to take out a grant for somebody to file a 75 Act claim against them, and we do several of them. I prefer to get the legal instruction from the person who's planning to take the 75 to find someone to do it through, rather than finding out at a later date. But also there's the level of then proof to prove somebody is cohabiting. And that sort of side is something which we do a reasonable amount when we look at land registry and unregistered property to work out beneficial owners and such. So going back and looking over electoral rolls to say, well, they were on the electoral roll for the last 5 years, or we can prove that they've got utility bills under their name. So that side may actually bring it in more. Will it change what we do and how we look at it? No, not really, because it just means we have to be more aware of the order of entitlement, and the order of entitlement now has got someone else pushed in between. Where an air hunter and where a genealogist should fit in is never really finding a close relative. It's never finding the spouse. It should never be finding the children or that sort of side of it. We ideally we'd only ever deal with cousin cases. We do find quite a lot of near kin now, but it just looks at the different order of entitlement. I've always said it that we did air hunters that was viewed by 3 million people every day for its 12 week sort of period it was going out. Huge amount of publicity around it. People always said, well, why are you doing this? Why are you standing up and telling people to write a will? Because surely that will do you out of the business. Fraser and Fraser look at 6,000 estates a year. There are 400,000 people who die in the UK every year. The number which Fraser and Fraser and air hunters look at is relatively small. So nothing's ever going to really change from that point of view. So am I worried about it? I think it'll change and dramatically reduce our business and what we do? No, I don't think it'll make the slightest bit of difference. There are lots of other areas which I'd love for emphasis to be put at the moment, because I think the 75 Act claim is relatively good. I think it could probably have its time periods extended, so it lasts a bit longer than the 6 months from the date of grant. But those are sort of minor adjustments. I mean, I've got written down, the last thing I've got written on my pad is California, they have a law for the predeceased spouse's family on an intestacy matter. So if we were to have a person who dies, then the predeceased family comes in. Why on earth would you ever want that? Well, if you've inherited something through your husband, and then it goes off to the husband's stepchildren, does that seem right and fair? No. So there are lots of areas which we can look at on the provision of inheritance side and the order of entitlement. But quite frankly, from the cohabiting side, I think the 75 Act probably needs a little bit of polishing, but is where we should land. So
good points, and thanks Neil. It's interesting. I mean, the 75 Act, does this come into dispute now? I mean, I know we're treading a bit of a tightrope, but if we're looking at introducing something to the sector that is different, then does that put a question mark over the 75 Act, Katie?
Yeah, so I think it's going to be really interesting how they sit alongside each other, because exactly the point that Helen made earlier, You can opt out of these intestacy provisions coming up for cohabitees by making a will, but the Inheritance Act provisions are still going to be sitting there. These are still going to be used. What is really interesting is that point we discussed about earlier is the financial amounts. So when they are getting more or clearer specific amounts under intestacy, how does that sit alongside the provisions of that Inheritance Act, and how that financial provision is calculated? So for me, that is where those two things are going to rub up against each other, and that's going to need a lot of clarification. So I don't think that this can't replace it. So the two are going to exist alongside, but have points where they're not sort of working in the same way.
Okay, thank you, Katie. Sinead?
Yeah, I was going to say the same. I think they just need to align. If they're going to make any changes, it seems just stupid to have a 2-year rule on one and a 5-year rule on the other. Like, let them talk to each other so that it's just not creating unnecessary confusion. I think the more that we confuse the rules and make more and more grey areas, it's more reason for people to put it off. People think it's a headache as it is. We've got to make it clearer for people, really, really clean cut, as black and white as you can make it. Then I think the education steps in and people can be better informed to make the decision that they want to make.
Thank you. Helen Claydon, what do you think is the biggest risk to the professionals that are working in the sector that are going to need to deal with this? Is there a risk, or is it really not a risk to the professionals at all? It's the risk entirely sits with the British public, who have to sort themselves out.
That'd be nice, wouldn't it? Yeah, it's all your fault. You're not educated, so it's your fault for not planning in advance. I think from a professional point of view, it's just going to make the advice a little bit more complicated around it, whatever provisions they bring in. And when you're talking to someone who's writing a will, you're obviously talking about does this person understand the people who have effectively got a claim against their estate? And you're then going to have to explore different relationships. Are they cohabiting? Are they planning to cohabit? Are you still married? You know, Neil made the interesting point earlier about you could effectively be in both relationships at the same time. Yeah. We always talk about previous spouses and that they might still have a claim if you haven't decided to get divorced. And we come across that quite a lot, where people separate and it's amicable and they choose not to get divorced. So I think from the advice point of view, it's going to be more complicated. I think the tax thing is a big issue that I think Katie or Siobhan maybe raised, Sinead, sorry, not Siobhan, okay. Wrong name, raised earlier about the inheritance tax, and that actually they're not talking about aligning that at all with the new provisions. So that's going to complicate things, where people are actually going to maybe think about making provision for cohabitees, but then there's not going to be the same kind of spouse exemption that will apply to that gift. So I think that will be more complicated. But yeah, I think from a professional point of view, the good thing is, if we've got someone sat in front of us, it means that they've already got that knowledge and they're already talking to us. We can fix it all by getting a will in place effectively, subject to Martin being involved further down the line, of course. But yeah, if we're speaking to someone, it is all the people that are out there who are accidentally falling within this category, not understanding what that might mean for them, and not getting any advice because they don't know that they're in this situation. I think that's the bigger issue here.
And that's going to then follow on to the estate administration, isn't it? And cause all these further problems. Helen Forster's got her hand up.
Yeah, I just wanted to tack on with that, with what Helen was saying, because this was actually an interesting point that was being discussed during the committee. Was, if you have, and I'm going to a will here, but I will come back to the cohabitee in the same way. If you have a couple that comes to see you and they want to write a will, And quite often what we do as practitioners, we take the instructions, don't we? We see them, we'll discuss things with them, we'll take the instructions. But the problem you've got is, should you be doing that? Are you in a position then, if things go wrong, they've been in the same room together, there's a potential conflict there. And I think the whole thing comes round to, if you have a couple that are just cohabiting that come to see you, we do the same thing, don't we? We'll take those instructions, but how are we going to, as professionals, manage this risk? One of the proposals is you should take will instructions, and it quite clearly says in a lot of the case law, take them independently, to sit people outside of the room. And so many people then say to me when I raise this in sort of courses and things, they say, well, how can you do that? Because they're going to get really uppity about that. I say, no, it's just an education. So their wills are more robust. If you take those instructions, you can do generic information about what it is, and then kick one of them out, take the instructions, and vice versa. And you're more likely then to get sort of the sort of belt and braces approach and protect yourself as a professional. And I think the same thing, if we're talking about mitigating risk here with cohabitees, I think it's even more prevalent. And do you then argue that in all of these, if we're talking about capacity, should we have a capacity assessment? You could go this is another rabbit hole, isn't it? How far do you go down to protect the individual, but also ultimately the professional? Because it's our practicing certificates that are on the line at the end of the day if there are these issues. And I think it's just a really valid point that Helen's sort of saying here, is mitigating your risk. It'd be great to turn around and say, well, on your head be it. But also, how have you imparted that knowledge? How have you got it to them? How have you covered your own back in terms of how have you proven you've given that information? Just having an initial meeting, they don't go any farther. Have you documented that? How are you having that? There's so many issues in how you're going to give that information that could come back to bite us. And I think unless we get some good practice notes all agreed in terms of how we do that process, I think we could be in a problem. And this is where, firms like Martin are going to see this all the time, isn't it? This is where this inevitably comes to you, isn't it?
Yeah, I think what's interesting, and what you've done there is provided the most perfect preamble to one of our products, but there we go, is insofar, far be it from me to turn into a sales call, but insofar as the Law Society, I had this conversation with Katie yesterday, that the Law Society protocol on the 1975 Act advice for will advisors and estate planners has been around for a couple of years. Vast majority of lawyers and will writers have not a Scooby-Doo that exists. And actually what it says in there quite clearly is that you have to, or you're expected to, and you have to give advice to somebody making a will about the existence of the 75 Act. But more than that, who, bearing in mind the planning decisions that they are asking you to put into effect, what that is likely to create in terms of a potential risk, claims, who can bring it, what might happen, and therefore the considerations you should be giving. That has to be given at the front end. The note goes on to say a failure to do that could be considered to be negligent. Now, at the moment, there's not a huge amount of case law, in fact, very little, but the way the case law is moving is that people are looking to try and find recoveries from people outside of the family, and lawyers will be fair game. So you talk about this professional. So you're talking about not just non-contentious probate lawyers, you've got some incredibly experienced ones on this call, but they all run teams, and they all run teams made up of, tens, sometimes cases hundreds of people seeing the public advising on will and estate drafting. You can imagine Helen saying to somebody, well, no, I'm going to see you independently and sit apart, and it would happen. Try that on a 25-year-old who's having a go. Is that's unlikely to happen. So what we're finding now is if you change the 75 Act to make it even less clear about what could happen. Oh, and remember that if you revoke this will, then you tear it up, then this will is gone, and therefore I know you've only been living together for 2 years, but actually if that turns into 5, then you can imagine. And this is the kind of problem at the front end of education, and that pressure is on the will writers and making that work at the front end, and they're being asked to advise on contentious matters as non-contentious wills and estates lawyers, which is, invariably we've always got involved at the end when it's gone wrong, and we start to get involved. So what we're trying to do is to empower that particular question to be resolved using tech, which we can do. So we can sort of feed the permutations in, and it throws out a note, as you say, Helen, nice bit of due diligence that sits behind it, and it goes in there. That doesn't take away the fact that the client could still very well face claims coming in, and unless we actually see this as something that improves the current position, My fear is it's just going to be more complicated, and actually it's going to be less engagement and understanding from people, and therefore probably less than 6,000 law firms dealing with private client work. We all know a fair chunk of those. Do we expect that group to give this kind of advice at the front end? They don't have the time. You know, the bigger organisations don't have the time, the margins, and very often the smaller ones aren't even aware of it. So it's, yeah, it can be done, it can be managed, but I do think we need to compare existing with new before change.
Martin, that we already, we will train all of our will advisors that are out there. If anybody's been identified as a potential claimant under IPFDA, then alongside the will, we'll get them to sign an IPFDA statement that just sets out, this is what I've done. For two reasons. One, to try and protect their wishes and evidence that they did actually think at least and consider these people, but also to protect ourselves.
Oh, God, yeah,
you know, we did have this conversation, we made them aware, they chose not to include their adult child who they believe is completely financially independent, and we'll get them to sign it. And honestly, I would say at least half of the wills now that we prepare end up needing a statement signing alongside of it.
Does not surprise me at all. And that's really what we've tried to face into ourselves, is this: everybody should be doing it, must be doing it. Let's make it super easy, super quick and consistent across everybody doing it within your business. And that's, but that, again, that's the education piece, isn't it? I keep coming back to the same point. It'd be terrible in the edit, Darren, because I'll be saying the same thing over and over again. It's literally, let's compare new with old before we make a decision to change. And if it's not better, don't change it. Use the money to educate rather than actually to try and, you know, let's not HS2 it. You know, let's actually use the money wisely.
I think I'm looking at the time, and believe it or not, we've been talking for the best part of an hour and a half, which has flown by. And personally, I would love to carry on talking. I'm so aware that you are all incredibly busy people and probably have a million other things to do. So before I thank everybody and kind of say cheerio, I just want to bullet point two things, because we talk about internal training, which I think is going to be vital. I think it very much starts with what the teams are saying, their understanding. It's great to hear Sinead and I know Helen Claydon, certainly. I know you guys very much on your training, very much getting the right people in, and that the teams are doing it. Katie and Helen Forster, I'm 99.9% confident you're doing exactly the same thing, because there's that hurdle. So the internal training is going to be vital with this, because if you can risk mitigate, and this is an area that I work quite heavily in, albeit a slightly different field, that's got to be the starting point, hasn't it? But we talk about education, and I'm just going to fire this out very quick, kind of a dozen words on how you think we're going to be able to do this. Some masses of pressure, apologies in advance. I'm going to start with you, Helen Claydon, so you brought this to the table, so I think it's only fair that I fire the question to you first. How do we educate the general public to be aware of this new Potential Act?
Well, I think that's bigger than us. I think that's bigger than us, really. And it's going to require some serious investment. And maybe that is the solution, that instead of looking to change the legislation to put us in a position where you're accidentally including people in a category that our own research says that they don't want to be included in, because if they wanted to, they'd make the conscious decision to get married. That actually those funds, as Martin said, should be better spent at a higher level, at a government level, of educating people about writing a will. And that's what it all comes back to. You can completely opt out of the current legislation if you don't agree with it, the proposed legislation if you don't agree with that. You can opt out of all of it by getting a will in place, and that's what the education piece has to be, I think.
I agree with that. Does anybody disagree with that?
Maybe just being more robust with what we've already got, like the cohabitation agreements, like the things like that we've already got. Maybe we need to couple it with what Helen's saying there, in terms of why change the legislation? We've already got these things. So is it not firming these up and making sure that they can be utilised in the way they should, which then tacks neatly onto sort of Martin to sort of deal with those protections and the things that he's got there for professionals as well, and that comes full circle.
I'd like to know, Sinead, do you think that this is being rushed? And do you think that more time needs to be taken by the government before they make a decision?
Yes, I do think it's rushed. I think it's just pulled out of the bag, isn't it? So you can't say it's been rushed in the sense that it's been on the table for quite a long time, but it's picked up, it's looked at in some detail, and then it's dropped. And then when it's picked back up again, that's where I think it's then being rushed. And I think it's just to try and appease people, to make it sound like, you know, we're listening to people. Although from what you've actually said, Helen, on doing some market research, people aren't saying that they want that. So I don't know what's prompted them to say now's the right time that we need to make this change. It doesn't feel like it's very informed.
No, but absolutely. Katie, what are your views on that?
Yeah, very similar, really. I think this act is much bigger. This is one strand of the 3 strands of the act, and I think there are elements of the rest of it that might get traction, and the danger is actually this just gets pulled along with it, and that's I think where my concern is, and where we have to be robust in our kind of responses to the proposals, because that's where I can see this coming from, is that we just get dragged along with everything else, and that part isn't really thought through, because the government don't always think through what they put in place, and it's when you see those problems come out afterwards. And for me, it doesn't feel, I think you'd get very different market research on the end of a cohabiting relationship and how assets are split versus how assets are split when somebody passes away. It just feels two very different camps, and for me, we need to make that quite clear.
Neil, from what you've heard today, being a service provider like I am, we're kind of the odd ones out, I suppose, in this room. What are your views?
Well, I can understand exactly why it's been brought up. It's been brought up because 47% of people think that common law marriage exists, which is a huge problem. That's exactly why this whole motion is on the table, why it was in 2011, why it's going to come back and all the side, which totally goes down what everyone's been saying about education. And we need to teach people about writing a will, about common law not existing. One thing which we certainly can't do is use a new act to replace the 75 Act, because the 75 Act covers more than just spouses and cohabiting people. So that cannot be forgotten. And if we start messing around with the cohabiting bit of the 75 Act, then we have to look at the whole lot of that as well to ensure that the rest of it is still protected. The whole aim has got to be to look at those who are vulnerable. And my first starting point on that vulnerability is going to be children, whether that's from a blended family where we've got children of different ages, and the possibility of children being disinherited because of a later in life cohabiting arrangement seems to be wrong to me. And I know everything can be opted out. We can opt out by writing a will, and that's the side I think we need to be going down. But Darren, you're absolutely right. I'm not a lawyer. I am a service provider, and I'm just someone with an opinion which I like to spread. So.
Neil, listen, I'm the same, my friend. I'm the same as you, and I think this is what's great about these forums, is that we can get together. We all work in the sector, and we've all got an opinion, and it's great listening to both Helens, Sinead, Katie. This is what I love, is sitting down and getting real people, professionals in the sector, looking at real issues, what could potentially be a real problem. Not just for us, but for the British public. So, I mean, look, everything that we've discussed today is really important, and I'm gonna ask Martin, if he doesn't mind, just to give us a final thought on this.
I think the reality is that what already exists is a very busy litigation world surrounding what happens with people's money when they die. 2/3 of people have no will. It's almost impossible. We had a go at this in a way, though, to draft intestacy rules that work for everybody. They invariably don't. So what you end up doing is try and produce an act, some protection that will allow clear wrongs to be righted. And that's what the 75 Act did. One has to remember that pre-1975, you couldn't even do anything. You know, your spouses, never mind anybody else, if you got left out. So for me, the litigation will move around. I don't think this will solve that. So I think we're busy now, we'll be busy later. I don't think that will change. I do think, for me, that the key thing is to speak to the contentious probate lawyers. It's quite interesting that talking today, you can see a lot of the discussions are about uncertainty, fighting, and all the rest of it. Why is not bigger delegations of contentious probate lawyers sort of setting out, like we've done, we've tried, to say, well, these are all the problems with it, so correct them. And if you can't correct them, then let's stay where we are and educate, which is what backs up everything else that everybody's been saying today. And that was my position at the start. Listening to everybody now, it's kind of got a bit firmer. There are no silver bullets to fix it. So let's work on getting people to make wills. Just something occurred to me as listening to people talking about, Helen was saying about, let's get people making wills when we can get them to make the wills to change that. How about, and here's a thought, why don't you make it mandatory that you have to have a will to register a property after you've done a transaction? Just an idea. Is that you have a property sale or a transaction, why don't you make it mandatory that somebody, and I know I'm not saying that will stands forever, you can revoke it the next day, but at least it's given thought, time, energy. I would imagine most mortgage lenders would fund it, just an idea, and say, let's do that. You know, that will make sure then that more people are making wills than they are now, particularly at the important time of acquiring or moving property around. So it's again, just an idea, but I think that's one example of perhaps where education could be looked at to change the attitudes of society, which is we're all too busy to die, don't want to think about it, not going to think about it, we'll just see what happens. My mate down the pub says, I'll be fine, so I'll be fine. You know, and that's still a problem.
I love the idea about a compulsory will on a purchase or a sale. Neil, sorry.
I hate the idea of being told and compulsory wills, and certainly linking it to property sales, because in a lot of in several situations, then the property may not be the big thing. There are a lot of people whose wills are incredibly complicated, and to try and force someone to put in a incredibly complicated will, which could potentially hold up a property sale or be forced through at the wrong time, is opening up a whole new kettle of liabilities. And yeah, I'd hate the idea of being forced to make a will when maybe that's not the correct thing to do. And certainly if there's a time scale put on that to make that go through incredibly quickly, so it deals with a property sale, yeah, not for me, thank you.
It's all right, Dale. It's not on the statute books yet. You'll be all right. We'll just
thank you.
Yeah, just an idea.
I love this. I'm secretly sitting here kind of being all Mr. Dr. Evil in the background. This is, I love, but this again, this goes back to what I was saying earlier on in seriousness about conversation and about bringing people together and different thought processes. Okay, final thoughts. Katie, anything that you would like to add as a final thought to the meeting?
For me, it's just, I really hope that they pause and take a breath and listen to the advice that's coming back, because this feels rushed, and this didn't go through last time, but it would just be a watch this space, and let's hope they take everyone's views into consideration.
Thank you, Katie. Sinead, last thoughts?
I'd just echo what Katie said. I think don't try and push a square peg through a round hole for the sake of it. You know, I personally am going to put my neck on the line and not sit on the fence and say, I don't think that it should be done. I really don't. I think we've got the protections in place right now to allow the people who need it, and we need to look after and protect the vulnerable. I think we've got the right channels in place right now. I think it's a waste of money.
Lovely. Thank you, Sinead. Helen Forster, final thoughts?
So I can understand why we want cohab reform for the family lawyers and for things like how they're going to work that. And there is an absolute place for this conversation. I think from the purposes of private client and inheritance, as we're all saying here, we've got the tools. We just need to work on them. And it's that work smarter, not harder. What's the point in having to do all of this when we actually could smarten up what we've got now, get that education to the profession, to individuals? There's lots of ways of doing that. Martin won't sit here and say this, but I know there's a lot of sort of really good sort of places where you can learn. There's lots of hubs. IDR have it, Estate Research have them. There's these places you can go, and it doesn't cost anybody any money. They don't tell you this because, of course, they can't sit and promote these, but I can. And this is where professionals can learn. It's just we're not actually, I think it's that we don't know what we don't know. If we don't know, we need to know this. How are we going to tell the actual sort of individuals that they need to have that? So it's this twofold problem. But I think if we use what we've got, I think we've actually got the ability to nail this without having to change legislation. I think we can better deal with this. It's just how then we go about doing that and how we can drive that change. And that's what everybody needs to get on board with, isn't it? That's the thing. We all need to get on board with that.
Thank you, Helen.
I think probably the highlights that I'd probably like to make following our conversations is it does create a massive sideways disinheritance issue that I think is like an unintended consequence if cohabitees are inheriting estates above children. Because then it can, obviously the wealth can go down a completely different strand unintentionally. And I go back to the inheritance tax thing that they've not even considered as well. So we've actually submitted our response through the website. We've got that response in already, and hopefully a lot of the rest of the profession are doing the same, because I don't think we're on our own with our thoughts.
Thank you, Helen. Again, thank you to everybody who's joined us today. It's great to have so many leading minds just come together and sit down and talk about things that are just really important, that, you know, other professionals in the sector, I think, are going to really appreciate the feedback and the thought process that you've all put forward. So I certainly, again, I always do learn so much sitting back and listening to the minds of you very educated, very wonderful people. So thank you. What we will do is we'll bring this meeting to a close. Thank you, everybody, as always, for being part of this. And yes, we look forward to sitting down and getting together again soon with another subject.